So, on today's episode, our guest is someone I met at one of my events I was hosting in Port Harcourt. He offered to take pictures for the event, and that was how I think we started talking for them. But I think that was like our first physical meeting, and since then we've kept in touch. So, when the case study of today came up, we had a bit of a conversation on one of my groups, and then in my private message or my DM rather, and I invited him to be a guest to give us an insider's view from a photographer's perspective. And now this case I'm talking about is the Wakanow case. So he proposed the Wakanow case, and I added two more cases, which you will find out later in the episode.
IP, IP,
IP,
IP,
IP,
IP, IP, IP, IP. Welcome to IP series, home to all things IP related, where I give you the stories, tips, and implications to business and creative decision concerning your intangible assets with real life case study. I am your host, Rita Anwari-Chinda. Subscribe and turn on your notification so you don't miss an episode. Cheers, guys.
So if you're a photographer that wish to protect your creative work from being used without your permission or being paid any form of compensation, like we will see in our case study for today, or you're just an internet user who wants to share and enjoy images online without worrying about legal issues, if so, you might be interested in listening to this conversation between Abam and myself. So we're going to explore a lot of controversial topic, but more from Abam's area, and then I will share a very tiny, minute detail, doing a little bit of comparison between what is obtainable in the US and what is obtainable in Nigeria.
All right, kindly introduce yourself. Tell us where you're based and what you do.
Okay, my name is Abam Miracle. I am a student of the Nigerian Law School, Lagos campus. So I'm preparing for my bar final examinations. So thank you so much for having me.
It's a pleasure having you as well.
So in my introduction, I stated we'll be discussing three different photography cases. The first is Abam's favorite, which is the Patrick Ikweme against Wakanow. The second is the Sun Girl case against Daily Newspaper. And the third is the Andy Warhol case, which is one of my favorite photography cases that I have reviewed in the last 3 years. So let's get into it. So now that we've met Abba, I'm just going to tell you how this conversation got to this point. So I reached out to Abba in the DM after we had a brief conversation on the entertainment and IP group for lawyers and enthusiasts based in Port Harcourt, and he agreed to be a guest on my podcast. So we're going to dive right into his most favorite case, which is a Patrick Ikweme against Wakanow, where Patrick, the photographer, sometime in July had alleged that Wakanow infringed on his copyright by using the photograph he took of the Ofala Youth Carnival during the Otala Festival at Zik Roundabout without his consent, permission, and authorization. We understand the concept of CPA when it comes to intellectual property work. So Wakanow had used that exact photograph, or the photograph in question, in their social media campaign ad on Twitter. Now, Patrick is demanding 50 million naira as compensation, whereas Wakanow's response is that the photograph was an independent creative process, the roundabout is an official state symbol and therefore not eligible for copyright protection. They're also alleging that Mr. Patrick's statements were defamatory and are demanding twice the amount that Patrick had requested as compensation for the infringement. So let's delve into this story. Abam, what are your views as someone who, you know, has been behind the lens before going to law school?
The photographer who took a picture of the Zik roundabout in Anambra State. So,
Is it just the
Wakanow
secret
being,
about?
yes, it was the Zik roundabout comprising of the sky, the roundabout, and some persons who were like dancing. So I think it was during a festival, maybe. Yeah, but there were persons like kind of
Yeah,
dancing
the
in
Opala
front of the,
Youth
yes,
Festival at Zikran Nisha, Anambra State.
okay, okay, okay. So that was, so then Wakanow being a travel company, they decided to do whatever they felt like doing by using the photographer's photo.
Look at this case. Yeah, carry on. I'm listening to you.
All right. So Wakanow used the photographer's picture, and they admitted using the picture because after using the picture, they are claiming that that photograph of the Zik roundabout is not eligible for copyright protection under Section 3 of the Copyright Act. So 2022. So, and they're also counterclaiming for defamation because the photographer has made some kind of public allegations against them, which is causing their company to be in disrepute. So that is the facts of the case. So now we'll be looking at the whole issue boils down to the interpretation of the Copyright Act because from what has transpired between the parties, we can see in their pleadings that there has been an admission of the use of the photograph. So the photographer he doesn't need to prove originality, or he doesn't need to prove all those basic grounds for copyright protection. He doesn't need to prove those basic grounds, that's originality and fixation and so on, because there has already been an admission of use of the photograph. So now, what is, for me, the bone of contention is the interpretation of the Copyright Act, of which permits me to read the section of the Copyright Act, which the company, being the defendants in this suit, they are they are placing heavy reliance on. So that Section 3 of the Copyright Act provides that the following shall not be eligible for copyright: ideas, procedures, processes, blah blah blah. Then now Section 3 sub paragraph C says that official state symbols and insignia, including flags, coat of arms, anthems, and banknote designs. So Section 3 paragraph C of the Copyright Act saying that official state symbols and insignia, including flags, coat of arms, and official translations, anthems, and banknote designs, they are not going to be eligible for copyright. So the interpretation of this section now would require some basic interpretation, which every law student should know those literal rule, golden rule, and so on and so forth.
Mm.
All those basic things that we learned in legal method. So for me, I think the most applicable rule of interpretation, which would be in the interest of justice for both parties, is the ejusdem generis rule. The ejusdem generis rule. And my reason for saying that is when you look at a proper understanding of the application of that rule, the ejusdem generis rule, is that where the interpretation of a particular word should be used based, it should be used in the generic sense to include those examples that have been given, from the generic, so the generic word. So what I mean now is this: the Copyright Act is saying that official state symbols and insignia, that's the generic word, that's the general word, official state symbols and insignia. And the copyright has gone ahead to give examples, that's things that fall under that category of official state symbols and insignia. So the copyright says that official state symbols and insignia, things like flags, coat of arms. The second issue that should be addressed after a construction of that section 3 sub C of the Copyright Act 2022, the second issue now will be whether the Zik roundabout, which is the subject matter in dispute, if that particular place is one which falls under an official state symbol insignia, going by the examples that have already been given, such as, for example, farms. So can we place the Zik roundabout? The question now is, can we place the Zik roundabout beside those examples that have been given in the Copyright Act, Section 3, Paragraph C? Can we say that the Zik roundabout comes under that section of the law? And it's glaring that the Zik roundabout is not something that has a state or a national representation of the Anambra state government, because the counterclaim of the defendants is that that Zik roundabout is an official state symbol of the Anambra state government. But that is not the case, because what the Copyright Act, the intention of the legislature in enacting the Copyright Act, what they intended was not to just put or allow any kind of public place to fall under an official state symbol, because that official state symbol doesn't have anything that has to do with it. Doesn't have any connection with the Anambra. Actually, it is merely a roundabout that was built by, I believe that should be the Nnamdi Azikiwe, maybe the Nnamdi Azikiwe roundabout, because the name is Zik, so Nnamdi Azikiwe. But from my own understanding of this, it doesn't come under that section 3 sub C. Yes. And now, my authority for saying this is when we make an international comparison between what is obtainable in foreign countries. Are you with me?
Yes, I am.
So if you look at the Eiffel Tower, I believe you know the Eiffel Tower, and most times maybe you've dreamt of going there, or maybe it's just chill under the Eiffel Tower. Yes. So the Eiffel Tower is one which there are copies over works that are made of the Eiffel Tower at night. So it is illegal for a picture of the Eiffel Tower at night. So that's because any picture that you take of the Eiffel Tower at night, they will not have copyright protection. And again, the Eiffel Tower is such that falls under the public domain, so nobody owns pictures that are created of the Eiffel Tower. So you can imagine how the copyright laws of France have developed such that they can actually appropriate certain artifacts to be owned by the government, as opposed to the Zik roundabout in Anambra State. That roundabout is not a symbol of the state. It doesn't represent the state. If you look at the Zik roundabout, you can only say that, okay, this is located in Anambra State. But the Anambra State government has not taken steps to appropriate that roundabout and clothe it against copyright protection. Because this is what you find in California. In California, you see the color. There are so many things that are that are like state symbols, state emblems in California, you see colors like blue and orange. You see some colors of you see some pictures of people who are a particular type of dancing has has been appropriated by the California government to be one that is an official state of California. So whenever you see people dancing in a particular style, you will know that that is attributable to the state of California. So that this is how copyright laws have developed when it comes to foreign states, and see in the Anambra State government and even the Copyright Act, Section 3 sub C only covers for anything that is attributable to Nigeria states. Yes, and take for instance, when you look at the 36 states, apart from the FCT, you look at the 36 states in Nigeria, you will notice that they have flags. Each state has its own flag. You see that the state of Lagos has flag, the River State has its own, Anambra State has its own flag. Now you see that these are what actually comes under that section 3, paragraph C. So not the Zik roundabout as a place, no. And again, of this argument would be whether that Zik roundabout falls under public domain. So under intellectual property law, you see that there are certain works, persons that actually fall under public domain. Shakespeare's works, such works that they've lost their copyright protection due to lapse of time. So those kind of works fall under public domain. So it means that those works are owned by the public. So anybody can make anything out of them, and nobody is going to be infringed on anybody's intellectual property rights. And if the Zik roundabout was one which fell under, as a place, it fell under the public domain, then taking a picture of the Zik roundabout would not vest any copyright protection on the photographer. But that's not the case, because the Zik roundabout fall under public domain. Although it is a public place, but it does not necessarily fall under the public domain for nobody to have copyright protection over them, because there are no laws that are specifically stating that such places fall under the public domain. So the work of the photographer taking a picture of the Zik roundabout is a clear case of, for me, the case is as clear as Andy Warhol's case. It's as clear as that, because the photographer has all rights to that picture that he made. Yeah, and the defendants have already admitted that they used the picture. So it's left for them to, okay, it is not necessarily left for them to prove that it falls under state symbols, because it is the defendants who are to prove. They are the ones asserting that that Zik roundabout is an official state symbol. So the onus is for them to discharge that burden of proof that the Zik roundabout is an official state symbol. And to do that is going to be difficult, because that Zik roundabout is not a flag, it's not a banknote design. It's not an insignia of the Anambra State at all. So I don't see their argument having any headway with respect to that official state symbol thing. So what do you think? For me, this is my clear thoughts, and this is how the case should go on in favor of the photographer.
What do I think? I'm not a judge now. I'm also an enthusiast and a practitioner of the field, you know.
Yeah.
But I think you made very good arguments
or comments regarding the case. I think for me, it's just for corporate bodies to know their boundaries when it comes to copyright infringement. What is that blurred line that you don't really need to cross? Do your proper due diligence. Make sure that whatever creative expression you decide to go after doesn't belong to someone else, and if it does eventually belongs to another person, you now have to do the needful by getting consent from the person, entering into a documented relationship in form of a licensing, is either a sole licensing or an exclusive license would work. But then coming up with an argument that because you think to your own mind and you haven't done your due diligence or consulted your lawyer, you feel that um, the work in question. And I think for me, like I stated initially, that they were focusing on something else. So maybe they were after the date symbol, but then the creative expression which Patrick Ikweme had captured included the festival at the roundabout where the state symbol is situated, and also the dancers themselves who were participating in the Ofala Youth Carnival. That's what I mean from a creative aspect. That's what you're looking at. But Wakana is saying, oh, they had like an independent creative process. So your independent creative process that if you come up with at the end of the day is the state symbol, which you felt, oh, we're going to use this as our argument that it's a state symbol and nobody owns it. We are free to use it. Are you actually free to use a government-owned property? Are there procedures that you need to, comply with? Just like you said, use the Eiffel Tower example. I think a lot of people are now becoming more aware of what is expected of you if you decide to want to use the Eiffel Tower picture or whatever. But yeah, I think it covers it. You now have to consider what will be the grounds for copyright infringement in the digital era post this case, and especially in light of the fact that we now have a new copyright act. And I'm also going to encourage photographers or photography enthusiasts like yourself, um, corporate bodies who are into marketing and advertising to also take their time to read what the law states about eligible works, economic rights, moral rights, the special provisions, etc., etc. So that's like my own, contribution to this case.
So let me also add this very controversial view from the US perspective. So you have what is called the SEVA test, which is considered to be a legal doctrine that determines whether a website infringes the copyright of a photographer by displaying it on its page. It also goes to say that if the website does not store a copy of that photograph on its server, but instead links to or embeds it from another source, then it does not violate the photographer's display right. This test has been used by courts in the US for several years, but it has also been challenged by photographers who feel that their rights are being ignored by websites. So Twitter is like a social media platform, so I don't know if it will qualify as a website. I know they have a web version, so maybe this might also fall under that. So it goes for that to say that photographers who feel that their rights are being ignored by websites that display their works without their consent or payment. Now, the origin of this test, um, goes to show that some challenges that photographers may face, such as piracy and unauthorized use, lack of awareness and education from the people or the photographers who are not even aware that they have rights, under the copyright law and how to enforce them. They may not even know how to register their work. So currently under the Nigerian Copyright Act, you can voluntarily register your um, photograph, which is an eligible work. The photography industry is a very, very highly competitive space, and with each year you find out that there are new technologies, trends, and opportunities emerging constantly, such as the conversation around artificial intelligence, the generative works. Um, Photographers now have to keep up with changes in demands and preference to their clients and audience, as well as the increasing number of computers who offer similar or cheaper services. Then the legal and ethical angle to all this conversation is that photographers now have to deal with various legal and ethical issues that may arise from their work, such as privacy, consent, defamation, censorship, plagiarism. Um, they have to respect the rights and interests of other people who are involved in or affected by their work, such as subjects, models, clients, collaborators. They also need to comply with laws and regulations of different countries. We are talking about Nigerian case now, but then we're looking at the several um, tests under the US jurisdiction. Now, this may what I listed as some of the main challenges that photographers face in their profession. However, there are also many other opportunities and solutions that can help them overcome these issues, which I would list out towards the end of this conversation.
I appreciate your angle of advice because it's more of a kind of you're actually giving an advice. You're just saying, okay, do your due diligence, do this. I am more
Yeah,
interested.
yeah,
I am,
the lost then is laughing at a small woman. It's so good, it's so good. So let's hear what you're interested in.
no, I'm interested in the damages that come out of this suit.
Ah, the damages, the damages is something else again that's really interesting. So, Patrick is asking for 50 million, while Wakanow is asking for how much was that again?
I think
100
over,
million. So it's like
yeah, 100 million.
100 million
Yeah.
for making defamatory statements. I
Hmm.
mean, seriously, is it really a defamatory statement if a copyright owner can prove that on this day at this time I saw this moment and I took a picture of it? And of
Hmm.
all the creative expression, independent creative process or works out there, is that particular one that caught your fancy? Why didn't you look for some other spot in Anambra or in Onisha? Remedies at the end of the day, it's like remedies that the court will give to a copyright owner in form of monetary compensation, injunction, account of profits, um, and there are certain things that the court will now consider. Was it for commercial purpose? Because obviously this was for commercial purpose.
Yes, yes, exactly. Very obvious.
Uh, a business doesn't get there to make money. Who doesn't know what can now? So what happened now? Ah, gosh.
Because the case the
Okay.
case is a very straightforward one.
What I would also consider would be protective measures as provided under the new act that a copyright owner can actually rely on. So, someone like Patrick, who alluded that he went to deposit a copy of the photograph with the Nigerian Copyright Commission. I mean, he has done the first thing that every copyright owner is expected to do. But now, under the new Copyright Act, you have protective measures where you put in technological protective measures to make sure that a third party cannot access your work and without having to do something illegal. So if you're not going to ask for damage, you not include that, oh, I took this step of including these technological protective measures so that someone cannot infringe on my work. And you see that this person went as far as doing X to be able to
Okay.
get access to my work, to be able to
Oh
use
wow.
it, and now he's now hiding.
Oh wow. That's very
Anything
that's
else,
that's
and
very
it went
very
through an independent
interesting.
process. So you don't have to go and attempt to do your evaluation.
Yeah.
Your evaluation and everything. So this is how much it cost me, and this is what I would have earned if this person had come to me to, get my consent, written consent, want to use my image or photograph for
Mm-hmm.
their social media ad campaign. And again, like I stated, the new copyright ads, I mean, they've done a fantastic job. The drafters did a fantastic job. We're going to give them their credit. Because prior to now, we never had anything like measures. You don't have takedown proceedings. So you have more remedies for you when you are going to be asking the court for damages. I mean, you do your C's and C's, go to court, file your proceedings, make your demands. So takedown proceedings is another way that you can actually make money from. You report the image or the advert saying this person has a copyrighted work, include the relevant documents in file, and let the internet service providers do their bidding. So the conversation will now be between you, the internet service providers, and Wakanow. Sure you get what I'm saying.
Yes, yes.
Yeah. So, you know, the court will only step in when it's necessary, or the Copyright Commission, I think, I have to look at that act again, will not step in where they need to, step in to do their job as from the administrative level. So, I mean, it's going to be an interesting case that photographers and companies, corporate bodies should really pay attention to. That is if parties don't end up settling um, out of court, which will now mean that we are probably going to be in the dark as to the terms of settlement. But then, what I like
Mm-hmm.
about this is that IP owners are now being proactive in terms of enforcing their rights. So everyone
Mm.
knows, oh, this person uses my work. I mean, social media court can do a whole lot that the court cannot do for you. But then the court is the one that has like the final say and precedent that you can use years and years and years, which will not take me down to our second case, which is the Daily Sun girls story. I mean, 7 years later, after asking for about 750 million, you only
Mm.
awarded 5.5. So, this is where the damages conversation starts again.
Mm.
And you're asking yourself, okay, where did I go wrong? What did I do? Was I not able to convince the court? Why couldn't the court grant me my request of the 750 million I'm asking for, or the 50 million I'm asking for, or the 100 million? It's
Mm.
a lot of work, because you
Yeah.
have to show and prove why you really deserve that. And
Yeah.
as they say, lawyers don't like maths, but then certain disputes will require that you have to put on your mathematical thinking cap and do your valuation and come up with a proper um sum that you feel is deserving to the copyright owner, which is the same thing that the court will consider, because you also need to show and prove to the court that, okay, if you put this side by side after doing the corporate body themselves do not appreciate what intellectual property really does for a copyright owner. You don't have to figure out whether they have like a good IP policy. Do they have a legal department that would probably guide them in the event of a dispute? And if they do not, what are your alternatives in that instance? So proving damage is one thing. Some jurisdictions have like a formula that everyone uses. I know what the law is talking about compensation for copyright is that the Nigerian Copyright Commission, if you're talking about way out, copyright commission would determine how that will be evaluated. The copyright owner will get their stipend after you've done all the plus minus, etc., etc. I'm trying to hold on.
Interesting, very interesting. I think I think I think um in making or in substantiate copyright claims and claiming for huge amount of damages, I think people should, or lawyers should put into consideration, how to actually determine damages and how to draw up all those big budgets. Yeah, because I'm just going through the that's the Sun case and Daily Sun case, and I'm just it looks very funny to see how they just came up with 750 million naira.
I mean, so when you're thinking about damages, you have to take into consideration several factors. And I think the counsel in that matter is someone I know. They probably would have done a good IP valuation. So probably um the lady Temitope had sent a cease and desist. Cease and desist is like intimating that okay, this thing you're doing is wrong. Oh, let's come back to the drawing table, and you're being all stubborn about it. Which is where conversation on IP tips for newspapers and magazines will come in. How they can protect themselves from copyright infringement, such as seeking legal advice and assistance, um,
Or maybe
and
even ADR.
yeah, discuss and license of the picture that they use, always crediting the original author, obtaining written permission, respecting the moral rights of the owner of the picture in question, which is something, when I was reading the case as well, I saw that written there that there were arguments on moral rights, and like, okay, this is fine because the new Copyright Act makes provisions for moral rights, which wasn't extensively provided for before. Now, the new Copyright Act provides that you cannot transfer moral rights only upon the death of the copyright owner, that it goes to the heirs or successors in title. Um, um, and then it elapses once the term of the copyright also elapses. That means the term of duration for protection has terminated and has gone into the public domain. That wasn't stated before. Same way you see in
Yeah.
contracts that people are asking
Yeah.
for rights in perpetuity. Now it's no longer in perpetuity. As the copyright ends, so does both economic and moral rights, ends. I know that moral rights seeks to protect the reputation and honor that a copyright owner enjoys. And in this instance, you're talking about the person's image. How do people see her when, okay, you open, there's a citation for the publication of the newspaper, 2016, something, something, something. And you see that, oh, there's this lady, a picture is a song girl. How was she looking? The people think that, oh, she was paid as a model to be the song girl. Was there a release consent form? All of this conversation kind of reminds me of the Adele case where her photograph was also used during the presidential campaign by the what's his name? Atiku campaign, and she also won. So people thought, oh, because of I saw her picture, she looked very poor, that she was suffering emotional damage, all of those things. Now everybody's talking about therapy. People are being more proactive or open or welcoming towards therapy. So she has to go through all of that. So that will also be considered when you're doing your evaluation on your damages at the end of the day. Take into
Yeah.
consideration all of those factors, and also the economy. We're in a different time right now. So 5.5 now, after 7 years, is it good enough? I mean, the sum as well. The claim they were asking for 750 was a lot, but at the end of the day, um, it's all about how you were able to persuade the court to see reason with you that you really deserve the
Mm,
750. But then again,
mm,
it's a good step in the right direction because now the courts what's the word now it's going to use? It's still a win for the lady, but then it also reminds me of the Banires case where her photograph was also used without her consent, but the court stated that she did not own copyright. So it's a bit complicated. It's all about show and proof. What are you presenting before the courts that the courts will give judgment in your favor? Um,
mm. Interesting.
so, um, so what are your
The-
thoughts? I mean, you said you've looked at the case. What are your thoughts with
Okay,
regards to the case?
apart from the damage aspect, is a clear case of them data breach of privacy. Yeah, that breach of privacy, and because the photograph wasn't used obtaining her consent and approval. So, but one question I would like to ask is if, take for instance, does it matter that your picture was being used and it projects you in a good light?
Define
Does
good
it?
light. So you're not going to be adding plenty issues. Define good light. I think the main issue is um with regards to so if you're looking at those kind of disputes, you consider the use and not the creative use. How was the photograph or the image used? And you know that for
Okay.
a copyright owner, they rely solely on the exclusive rights to control how they can reproduce, publish, distribute, communicate, adapt, translate the copyrighted work in question. So get
Yeah. Yeah,
copyright
I get.
owner looks they want to have some sort of degree of control. So if I cannot control how someone uses my image, good or bad, the bad part is where the moral right comes into place because you are protesting against any form of mutilation, distortion, modification of your image or photograph because it's going to cause harm and reputation. That is where the damage now comes in. How much harm and damage was done to you? Do the math. So the cost will be like 750 is not it's not reasonable. 5.5 is what we think is reasonable enough for you as the copyright owner at the end of the day. you know. Then the use again will also determine was it for commercial purpose, the Daily Sun make money from having you as a Sun girl, take that into consideration as well. Which will also make me talk about a little bit about the Andy Warhol case, which has been going on for a while now, where the photographer had initially licensed to the Andy Warhol Foundation, and then when Prince died, they decided to reuse the photograph. I mean, license was got in 1985, and you're coming in
Mm-hmm.
2000 and what to, there was no renegotiation or communication between parties. And as the Supreme Court recently held, they have said that Andy Warhol actually infringed on Lynn Goldsmith's photograph of Prince. So you see that from the three cases, there's a middle ground that we're talking about photographs at the end of the day. Who owns the photograph? Is it an individual in this case, or the person that was commissioned to take it? Um, what is the degree of control? What are the available commercialization model that the copyright owner can explore, which is where um, they get to control how it's being monetized and exploited. If it's exploited for good, at least let's see the economic right that you get to generate at the end of the day. If
Okay.
it's for bad, the moral rights questions will come into place. Um, you know, and again, like I stated, the moral right provisions under the new act is a good, welcome and good development. The protective technological measures as well, and also the takedown proceedings as well. So for photographers, I mean, you have more options right now. And also for copyright owners, you also have more options for enforcing your right. Nothing like, oh, we don't have the laws. Now we have the laws. We're not going to be comparing jurisdiction with foreign jurisdiction because they have their own issues. They're dealing with, AI generated images.
Mm.
Last year it was NFTs. Now we're talking big data, large language models, and generative work. That's where they are. We were still battling. Oh, it took my photograph that includes the Zik roundabout, the Ofala Youth Festival, and this. So our cases are very peculiar, and we have to focus on those things and stop comparing. We also need to have our own standard at the end of the day when we are, trying to create ways to resolve these disputes. So you decide to so you have three modes. I always say you have three modes of resolving. You have the administrative mode, which is involving the IP body or the IP registry at
Mm-hmm.
whatever stage. And then you
Mm-hmm.
have the court if you want to appeal the decisions of the administrative body. Then you
Mm-hmm.
have out of court settlements and or online dispute resolution mechanism. Now people are having proceedings, both litigation and ADR proceedings um,
Yes, online.
in the
Yeah. Now,
metaverse uh, online. You know, what are the guidelines that have been put in place to ensure that even while you're trying to resolve your dispute, your privacy is considered? Um,
mm.
are there going to be IP issues that will arise from that? No one can really tell. But then, um, I think I'll say for me, in summary and closing, is that we need to have like a broader or interpretation of what boundaries of copyright infringement really entails in Nigeria, whether it's for photos, image, sounds, music, literary, artistic, or whatever form of eligible work. I mean, the law clearly defines what qualifies as eligible work. So someone going out of the purview of the law to state that, oh, our defense is going to be that your work is not. What do you mean? Which part of the work? Is it the expression of the photograph that you're referring to, or the Zik roundabout, which you claim or you state, and rightly so, that is a state symbol, you know. So, but that's it anyway from me. Yes, let's hear from you and then we'll wrap it up.
Um, for me, on that daily song case is just a clear. For me, it's a clear case already. There's really not much to talk about there. I think the more interesting one is your favorite. That's the Andy Warhol. Andy Warhol. Remember
So,
when I
so,
told you Andy
so
Warhol
the
featured
Zik
in Men in Black?
roundabout is not the Zik roundabout is not interesting. Eh?
It's very interesting, and I hope that case goes to court. I don't want them to settle out of court.
Ah, photographer, God, I have mercy. Eh?
Yeah, yes, yes. Because I really I love court proceedings because they develop the law. They develop the law. They clear all these ambiguities in statutes. So that's why I really
Okay.
want that case to go on. Yes, I want that case to go on. And again, take for instance, if I take a picture of Tinubu, who is the president of Federal Republic of Nigeria,
Oh,
do I own copyright in that picture? Considering that
mm.
Tinubu represents, he occupies the office as the president of Nigeria, and he is recognized internationally as representing Nigeria. When you see Tinubu, you see Nigeria. So do you
So
think a
I
picture
think
of
if you're not
Tinubu?
going to dissect that, you'll now be are you going to focus on your expression of what you saw when you were capturing Tinubu or President Tinubu as an individual or as a representative of the Nigeria as a country? You know.
Well, that is more factual than I expected, but
Ah,
um,
please give us your expert views right now. We want to learn from the from the
No,
spring
I did
of
not
the
say
god's eye.
I don't say expert. I just say expert view. I was just thinking that if it would be considered what I saw, take for instance, during the swearing in of Tinubu, I take a picture of him
Mm,
and I saw how he was being sworn in as the president. Yeah, or maybe there's a particular ceremony where Tinubu attended and he was dressed like the GCFR, the Grand Commander of the Federal Republic of Nigeria, and I take a picture of him.
mm.
Um, so as Tinubu himself, does he come under an official state symbol?
Ah,
Tinubu Act.
you're pushing the interpretation of official state symbol.
Well, that's why it is subject of interpretation because you say official state symbols.
Mm,
Now, would the interpretation of official state symbols be limited to those inanimate objects of flags, coat of arms, banknotes? Tinubu, as the
mm.
president of Nigeria, is he not an official state symbol?
You have a strong argument. You have a strong argument.
So, so I, but well, that's just an aside. It's an aside. The thought came because
Mm,
we're looking at official interpretation of official state symbols. The governor of a state
mm,
should be an official state symbol because he
mm,
represents the state. Yes, same way the flag represents the state. The flag of that state represents the state. The president or the governor represents the state as well. But
okay.
um, stretching it now to include places like the Zikran about it won't fly. It won't fly. It won't fly. So
So
that case is settled for
he
me.
said to me, Lord, the God's eye.
But I would still like to see what the photographer would argue. I would still like to
Mm,
see what they'll argue. So on the
okay.
whole case
Yeah.
and the Warhol, okay, for me these cases are kind of straightforward though, because it's just easy to show that I'm the photographer who made this original work,
Mm,
and another person has been contracted to, make works that are, yeah, make works. Could we say derivative works in this case? Because it was Lance Goldsmith's original pictures of Prince that
yeah.
and the Warhol silk screens of. So, but then the fact that you make a derivative work, it doesn't still absolve you of liability because the use, if the use is not one of a fair nature, in the sense that you're not using it for parody, for criticism, but rather you were using it under it was a commissioned work, in fact, you were given. Yes.
Mm,
So which was actually used for commercial purposes. So
mm,
those kind of reproductions are clearly copyright infringements because you did not obtain the license, you did not obtain the approval of the original owner of the work. So it's a simple case. And again, the fact that Lynn Goldsmith gave license to Vanity Fair in 1984 and that license was used, we could now see the operative nature of licenses. Do licenses operate, you know, do they run, how will I put it now? Do those licenses run in concurrence with the existing copyrights or intellectual property rights of the owner, or
mm.
they operate on a one-off basis? So we will see how these licenses they operate because take for instance, if Vanity Fair was given a license in 1984 and assuming that license was still operative, Vanity Fair now commissioned a third party to make reproductions of that photograph that they were giving license over. So what do you think? Would that license be a defense reproductions made from the original work?
I
Or
would say no, because I mean you have to now look at what the terms of the license state. Is there provision for you to sub-license to a third party? If yes, what are the preconditions that you have to meet before doing that? So, everything ties back to the documentation. What was initially agreed? It wasn't agreed with the consent of the photographer who is the copyright owner, then you are infringing. And just like the Supreme Court had concluded in that case, they agreed with Lynn Goldsmith that Andy Warhol's estate actually infringed on her copyright. I think when they were on appeal, the court also took they also considered the four-factor test, which we now have under our new law. It wasn't expressly stated before, but now it has been expressly stated under the new act that these are the conditions that you need to the four conditions you need to verify to determine whether a work was used for commercial purpose or for non-commercial purpose. The nature of the work, the extent of the work. Can't remember the other two now. So yeah, the contract will determine what happens um
okay,
going forward. Yeah. And then again that under our Copyright Act, the law states that any exclusive license must be in writing. So a written
yes, yes,
license between the photographer and the Andy Warhol estate will determine the relationship they have, the terms and conditions of licensing the prince's photograph, which was in dispute, how it will be used, what it can be used for, the jurisdiction, all of those things will be taken into consideration. So you want to pay a homage, okay? I'm rich. It's like the what's this? There's this footballer that died. Is it something Diego? Yeah, he there were this fashion brand. I think I talked about it also in my podcast and on Twitter. This fashion brand D&G, it should be D&G. They wanted to pay homage to Diego. They use his football famous number and his name, and they stated put the clothes on the runway stating that they were paying homage. Okay, you want to pay homage to me without telling me. I just let my head swear small now. I'll come that day. I could even follow them walk the runway, but no, they went ahead to do that and he sued them, and I think he got almost 11,000 euros that year or more. Can't remember now. But then that's like, everything now boils down to, like I was saying, there's always a meeting point in all these cases. There's an image issue, there's a photograph issue, there's the creative expression issue, there's the issue of um, use and the exclusive rights that the law gives a copyright owner to be able to commercialize and exploit their creativity that's already been put in a fixed or tangible format. I hope that makes sense or I answered your question.
yes, of course, yeah.
Fantastic, fantastic. So it's been an interesting conversation so far with you, Abam. I don't know if you have any final or closing words regarding
Mm,
photographs, copyright boundaries or copyright infringement, and your, final words on your favorite case. I know you're itching for it to go to court, but then let's hear you say something.
okay, I would I would just like to sensitize or rather encourage photographers like myself to be more proactive, and they should they should they should cultivate the habit of complying legally when it comes to protecting their images and their intellectual property rights. They shouldn't sleep. Don't sleep. Don't sleep on your rights at all, because any day, anytime, someone could just make millions off your work and you just
What if
remain where
what
you
if it's
are.
billions they're going to make? They're just getting it.
Yes,
I
yes, billions, because I love to dream big, so billions. Yeah, so you could do anything at all, and just keep your works. You don't know how your works are so valuable. When I looked at the photograph of that Wakanow, that photographer, the photograph was taken with a mobile phone. It wasn't a digital camera. In fact, professionally, he did not edit that picture to like a professional standard. You can't compare it to what those. No, I'm sorry I'm saying this. I'm sorry I'm saying
I'm
this, but
listening now. So there's a difference between taking pictures on photographs and taking with the likes of Sony and the rest of them.
of course, because
Hmm.
all of that could actually be assessed in you claiming for damages. Yes,
Hmm.
because when you take pictures with your camera, it will require you more time and process for you to, finish with the work. In fact, even at the
Hmm.
point of taking the picture, you're going to spend so much time and all that. So there's a huge
Hmm.
difference.
So
There's a
when
huge difference.
Agman states that it doesn't matter the quality of your work, so far as long as it's in a you've expressed it in a tangible or fixed format, the
Hmm.
quality really doesn't matter.
Okay, that's interesting for the law to, you know, make that
But
make that.
as a photographer, your views
And yes,
are
I was speaking as a photographer. Yes. So actually saying that as long as your work is fixated, is sufficient. It doesn't matter the adequacy of your work. Fine,
mm,
fine, fine. But my point is just that photographers should be proactive. They should always look out for people who would want to rip them, because there are rippers everywhere. There are rippers
um,
everywhere.
the
There are
streets need
rippers.
man.
There are rippers everywhere.
Well,
Everywhere.
okay. Thank you for your closing and thank you for engaging us. I mean, it's a pleasure speaking with the God's Eye himself. I hope you had a good time with us today.
Yes. Yes.
Okay,
I've taken so much time from corporate law. I'll have to pay back.
Lord, but it's thank you for coming on IP series and do enjoy the rest of your evening.
Thank you so much. Thank you so much.
Okay.
Just like Abba, my closing word would be, as a photographer, educate yourself and sensitize yourself on intellectual property rights. Take IP protection and enforcement seriously. You can also seek legal actions in court or explore alternative dispute resolution where necessary. Also, licensing and contracts are very important. And don't be scared of embracing new techniques and technology where the needs arise for you to showcase your work. It doesn't matter the quality as well. Now, if you enjoyed listening to this episode and you learned something new, if you have any questions or comments, please feel free to email us at ipseriesinfo@gmail.com. Until next time, IP friends, keep fighting for your rights and revenues as a photographer. This is Rita Anrichinda signing out.